Hello everyone. So today we will cover the learning objective 2 of legal terminology in communication, and this one relates to be able to present information in a legal context orally. So it is basically about oral communication and how they are used in the context of legal communication. In this session, we will be covering the different styles and methods of oral communication for different audiences, and also to present information in a legal context orally in a formal situation, and how to respond to questions arising from presentation of information. So these will be our core focus areas for today's session. So the first one is to use different styles and methods of oral communication for different audiences. So we learned a little bit about oral communication in our last sessions. So it is the process of expressing information or ideas by word of mouth. So it is generally due to face-to-face interaction between the participants. It can be one-to-one, or it can be like one-to-many, or it can be like many-to-many. So for example, two or three senior managers, they are addressing to the entire team. So that is a oral communication, and it relates to verbally transmitting information and ideas from one individual or group to another. So that is the core essence of oral communication. So the oral communication, it can be formal or informal. So it can be both. So why? What are the key characteristics for oral communication? So what do you need for oral communication? First and foremost aspect is clear pronunciation, which means that you should be very clear on what you're speaking in oral communication, so that the audience is able to interpret you and they're able to understand you. So your pronunciation should be very clear. Then precision, which means focusing right on the topic. So it should not be like getting diverted to other topics or any other thing. So the precision with which the words are spoken and in the context in which it is spoken is very important. Then there is a conviction. So when you're delivering a message, you should believe that message, and you should be like you should speak with conviction, so that you are able to create an impression on the audience, so that they are able to understand your message, so that they are able to accept your message. So that is the importance of conviction in oral communication. The next one is logical sequence, which means that the information should follow a logical sequence, and it should be coherent, means one logical sequence after another, so that the audience or the team where you are speaking, they are able to process the information, they are able to interpret it in a logical manner. So basically, they can make sense of the information. Then the next one is appropriate word choice. So this essentially means that you should use appropriate words. So remember, we had discussed in the last session that you should not use too many jargons or maybe things which may be difficult to understand for the audience. So an appropriate word choice should be there. And then you should speak in natural voice, which is your natural tone. So, and the best thing is that when you are communicating with a team member, you should uh, uh, adopt a formal tone and in a manner in which they are able to understand. The team is able to interpret the process and process the information. So that is, those are the core important aspects for oral communication. So now let's look into the different types of oral communication. So one is face-to-face. So the majority of communication in business is face-to-face. So you should understand the etiquette with respect to face-to-face communication. So since the communication with the different stakeholders is often face-to-face, a customer may enter the business to talk to someone about their needs and requirements. So you should know how to deal with a client when they talk face-to-face. You should understand what needs to be spoken. You should understand that you should speak with conviction. So that will keep the client interested. If you give like too many weird answers and all, the client will definitely, they may get disoriented, or they may want to speak to somebody else who knows what is the subject matter about. And in oral communication, you can get quick feedback, and the sender can thus make sure the message has been received and understood. So when you're speaking to the client, and if they understand what they are saying, what you're saying, and they get the message, so that itself means that your oral communication is successful, that you're able to transmit the message to the audience. And then another important thing to remember with respect to oral communication is that there is no written record of face-to-face communication for reference. So make sure that you convince your client or convince your team members, but just for the sake of a formal communication, you can write an email afterwards that if you have any issues, then let me know, or basically pursuant to a conversation, you can give a reference to the face-to-face communication. So, and if there are some points which the client has raised, then you can write those in email that during the face-to-face communication, we had discussed these points, and I would further like to follow these up. So that is the way in which there is a natural progression from face-to-face communication to a formal communication. Then speeches and presentation, these are also oral communication, but these are assisted with some kind of written artifacts. For example, presentation, if you're giving a presentation, you may have a PowerPoint presentation behind your screen, which is visible to the audience, and then you are speaking. So in this type of oral communication, it generally refers to the stand-up speech delivered by an individual from an outline or script. So there is some written context somewhere which is used as a reference for oral communication through speech and presentation. So this also includes group presentation or impromptu speaking. And then this type of communication, it is generally a monologue, which is like a one-way communication. So most of the government press conference, or probably even in the sports, most of the official communication by the government, for example, by the UK government and all, when they're giving a press briefing and all, it is generally a monologue. But a dialogue can be built with a question. For example, the press reporters can ask questions, and then the response can be given. So that is the way in which speech and presentation, which are another form of oral communication, is utilized by the different stakeholders. So the next one with respect to oral communication is the discussion groups. So the discussion groups, it basically is a structured, it is basically when a group discusses a specific topic. So a structured discussion takes place based on the common interest, and the entire group focuses on those specific points. So it typically involves participants who argue one side throughout, while deliberation allows for movement by individuals within the process. So this means that different parties to the group, they are allowed to speak out their views. It could be positive side, it could be negative side, and then a deliberation is done on like how to proceed in the next course of action. So it generally creates an atmosphere of a collective and a collaborative effort when working towards a project, or it could be working towards an idea, or addressing any problem. So that is what discussion groups are for. So it is basically focused on specific topics. Remember, discussion groups of informal communication are generally rare, but it may so happen sometimes. But discussion groups are more common with respect to official discussions and the formal discussions. So there may be some written informal records for noting down important points. So it depends on like whether the group members, they want to take notes. But if it is if it is a meeting with the higher levels, the minutes of the meeting are recorded in the discussion group. So that is a type of oral communication. So the next type of oral communication is the telephone calls. So which is another, it could be a formal call or it could be an informal call. But generally these are preferred as informal communication. So it can be whether internal, which can be through uh, like internet or the office intercom, where you can communicate with other team members or team members who are based in other cities and all. So that way you can communicate. And then immediate feedback is given. So if the audience, they understand your message and they respond as you want them to respond, then that itself means that the message has been conveyed to the audience. And generally, there is no written record of the conversation unless the phone calls are being recorded by the organization. So those things you need to ensure that if the phone call is being recorded, that means you should carry out only formal communication. You should avoid any personal talks and all. So it can often be quite dicey with the telephone calls. So now we have discussed the different types of oral communication such as telephone calls, speech, presentation, face-to-face communication. Now we look into what are the advantages and disadvantages of oral communication. So the main advantage is that it is time saving. You directly reach out to the person, you convey your thought, or even in group discussion, the team members, they gather together, they discuss an idea. So it is basically time saving, and you can see the quick feedback, which means that you can get a response. That means your message is conveyed. And this type of communication, it is generally applied in special areas. So it could mean like we said, discussion on specific topics. Then you have powerful means of persuasion and control, which means you can direct the conversation how it needs to happen. And then you have saving money. So you don't need to travel. You can just connect through them over the phone and all. So that is one of the advantages of oral communication. Then again, it's effective for all. It is more reliable as you get to know the point of view of the other uh, uh, individual or the team members. So you can understand, you can gauge the depth of basically what is their opinion on the issue. So that way it is more reliable. Then you have the flexibility, which means that if you want to speak to a team member, you can call them at your own convenience, and like you can call them at 11 o'clock, 1 o'clock, 2 o'clock. If they're not available, you can call them later. So that is the flexibility which is there. And then there is complete understanding. Like when two people are discussing any formal issues, then there is a complete understanding. But there are also certain disadvantages with respect to oral communication. So the first one is that of emotions. So if somebody is telling you and you are disagreeing, so the first person may like look at it that okay, you're not agreeing with what he's saying. Then the second disadvantage is that it does not have any legal validity, which means that whatever you say, unless it is being recorded, that there is no proof to substantiate what you have said or what the other party has said. Then there is the absence of permanent record, which means that if it is not being recorded or if it is not being noted down and getting signed by all the members in the team, then there is no validity of the discussion. And then it could be a problem for distance people. For example, if the group discussion is happening and somebody is staying like say 20 miles in another office, so it will be difficult for them to travel. So it will be actually problematic for them to travel. So again, it becomes a disadvantage to them. Then if it is a lengthy message, so some points may get lost. Like if it is discussed orally, so some points may get lost. It may not get due attention. So that is one of the issues in oral communication. Then you have a greater chance of misunderstanding and then distortion of meaning. So there could be multiple viewpoints by the different team members. So there could be a distortion or misinterpretation of the issue. Then if it is like a very tense environment in the group, or if two people are very tense when they are communicating with respect to the issue, then there is uneasiness to fix responsibility, which means that both the parties, they are standing firm in their ground. So it is uneasiness. They can be very uneasy, and then there is risk of leak of secret information. So if you meet somebody in person and you convey them some secrets, so there is no official record of it. So uh, like that is one of the disadvantages of oral communication. So next we look into how to present information in a legal context orally, and how to respond to questions arising from presentation of information. So since these two units are they relate to essentially the same content, so I have clubbed them together. So the first one is like, how do you communicate in a legal language? So it relates to the role of argumentation in law, which means that a lawyer must justify his case with arguments. There should be strong arguments which support his case. So the judge must support a decision with argument and with evidence. For example, in many legal systems, the judge has a legal obligation to justify his decision. So if there is evidence, for example, if you find that two competitors are colluding, and how do you justify that? You can say that they have met like 20 times, like they have met like 5 or 6 times over the last 20 days. So there is an element of collusion, and if you have the evidence that if your client has taken pictures of both of the competitors meeting together, so you can present them in evidence, and then you can lay out the case and justify the case with argument that they are colluding. So that is one way. That is the role of argumentation in law. And then the legislator must support his proposals with arguments. So arguments are very important, and they should be used along with proper evidence. And jurists may also justify the opinion with argument. So there should be some argument to support the case. Then there is issue of dialectic and rhetoric in legal argumentation. So one you have a logical approach, one you have the rhetorical approach. So the logical approach in the legal terminology, it emphasizes the formal aspects of legal argumentation. So basically, you can relate to a prior case, or you can relate to the specific rules and regulations, and then you can present your argument. Whereas the rhetorical approach, it emphasizes the content of arguments and the context dependent of acceptability. So under the for example, in logical approach, you can quote the previous case, but in a rhetorical approach, for example, if the sun, if the time is like say 10 a.m. in US, then it could be like say around 6 or 4 or 5 p.m. in UK. So in at both the times it could be correct, but the lawyer has to say that okay, he has to specify in context, like okay, this crime happened at 10 a.m. in UK, which was like 4 p.m. 10 a.m. in US, which was like 4 p.m. in UK. So he cannot say that the crime happened at 4 p.m. So it should be context specific. So that is the logical approach, and there is a rhetorical approach. Then the logical approach, it is a necessary condition of acceptability of a legal justification, which means that it is necessary, but it is not a sufficient condition. So the argument underlying the justification can be reconstructed as logical valid arguments. So you have the cases of Georges Kalonowski, and then according to Ulrich Klug, a legal argument can be reconstructed adequately in terms of a predicate logic. So to put it simply, it is the logic which is used as argument in the logical approach. So for example, you can take the precedent of a case, or you can say a logical step is taken. So that is what is the most common aspect in the argument of the case. But in the rhetorical approach, the acceptability is dependent on the effectiveness of the argumentation for the audience to which it is addressed. So, for example, you can address to some people in Africa and say that okay, after 8 p.m. the crime rate is higher, but when you address to some people in US, the same may not be the case. So it is the effectiveness of argumentation for the audience. So that is how it is addressed. And then a concrete audience, for example, a magistrate or a jury in a criminal trial. So you will address specific to those conditions. You will address based on their, so that they can interpret the situation and then they can come up with their own judgments based on the rhetorical approach undertaken by the lawyer. So why we are discussing this logical approach and the rhetorical approach? So it is basically to have to understand the audience, and so audience analysis is very important in oral communication, like we had also discussed in our earlier classes. So why so some of the examples are like experts. These are the people who know the theory and the product inside and out. They know how the product will perform under certain conditions. So they designed it, they tested it, and they know everything about it. So the non-specialist reader is less likely to understand what these people are saying, but also has the least reason to try. So basically, as experts, you need to have technical information related to the product. You cannot just give like out of the box context for the expert. So you need to say that since this product was expected to perform in this way, it did not perform. So therefore, the case lies with the manufacturer. There's a faulty case with the product. So that way you can argue with the experts. Then technicians. These are people who build, operate, maintain, and repair the stuff that experts design. So experts are basically who are the first line in any product or service. And the technicians, they are the second line. So basically, they are the ones who operate the product. So they have the high technical knowledge as well, but more from a practical nature. So the expert may have a knowledge with respect to the theoretical nature, but the technicians may have knowledge of the practical nature. And then the executives. So the executives, they make business decisions with respect to the product. So if it's a new product, they decide whether to produce and market it. And if it's a new power technology, they decide whether the city should implement it. So they use the product or service and then generate a business case out of it. So obviously they own responsibility about the performance of the product, and they also have experts and technicians in their companies to justify the products. And then there are non-specialists. So these readers have the least technical knowledge. Their interest is as practical as technician, but in a different way. So they want the new products to accomplish the task. If it does not happen, they may have an argument that okay, this product was expected to perform this way, but it did not happen. So that is the interest level of the non-specialist. So it's very important to understand from a legal perspective. You need to know your audience, like what you're addressing to the audience, what kind of arguments will hold, what is the interest of the audience, what is the expertise of the audience, what is the what is the role of the audience. So that is very important in oral communication. So in legal argument, you should always remember the 4 P's, which means the first P is planning. So define a purpose, analyze the audience, and then analyze the occasion. Like what is the occasion? Analyze the audience. Like if it is a jury, then you need to defense lawyer would convince the jury that okay, his client is innocent, whereas the opposite lawyer they would want to refute the theory, and then they want to convince the jury otherwise. So you should remember. So for both the lawyers, planning is essential. Then you have a preparation. So you develop the central ideas, you develop the main ideas which are focused around the central ideas, and then you gather the supporting information, so which can help you with the central idea. Then you have the practice, which means that you need to rehearse before you go into the actual audience. You need to be very thorough with the regulations. You need to be very thorough with the law. You need to be very thorough with the precedents. So that way you can get more practice. And then it should be like focusing around central argument and then being assertive. So this is what needs to be done. This needs to be done when you actually approach your main meeting or main argument or wherever. Then there is perform, which means that you need to begin with confidence. You need to be organized. So that is the performance that you need to do, and then pay attention to the audience. So you should be looking right into the eye of the audience, and then you should be presenting your argument in a very strong and positive manner. It should be very assertive when you're presenting your argument. So those are the 4 P's in legal argument that you should remember. So that is all for today. In case if you have any doubts, you can let me know.